Hi, it's Mike DelSignore in Massachusetts, OUI lawyer. Today's video, I want to talk about what happens if you're arrested by the Rockland Police Department. Cases brought by the Rockland Police Department will be heard in Plymouth District Court. It's a court I've been appearing at for a long time, so I can describe the process that you're going to face. So when you're arrested, let's say you're arrested over the weekend, your first court date will be for arraignment. At that date, you'll enter a not guilty plea. You get a further date for what they call pre-trial. What are some of the things we can do right away in the case? When you call me, I'll go over some of the potential defenses to your case. In other words, I'll listen to why you were stopped, what happened on the field sobriety testing, sort of give you an overview without the report of what I think some of the issues might be, what I think your best defense would be in the case. Now, once the arraignment happens, I'm able to review the report, able to give you more specifics. I have the government's version. I really do need that to give you more insightful information. So I'll be able to review the police report, see how you did on the field sobriety test, and then I can hone in on what the strengths of the case are. That's generally what I do. When I assess a case, I'm basically analyzing, say, is this a case where my best defense is the driving, the field sobriety test, or is it something else? Let's say your driving was bad, the field tests aren't good. My best defense might be you're a great guy, or you're a great woman, you're a great mom. You give to your community. So sometimes I can take something about your personality, about you, about what happened that night, and use it as a defense. People that are hardworking. I've represented a lot of people in the restaurant business, and I love handling those cases because if I can put forth evidence that somebody's working hard, they're out after work, that could form the basis of a good theme that it wasn't alcohol that caused the bad driving, it was that they were tired from a long day. So I try to find out what my angle is, what my best avenue of defense is. Sometimes I'll need somebody to testify if the case is strong, if there's an admission, something we need to explain, then I might need you to testify. But I'll go over that with a lot of practice. It's not as scary as people think. These cases aren't trials in front of a lot of people, a very small number of people in the courtroom, if any. Usually it's zero. So you're not testifying in front of a large crowd. Sometimes we do the cases with a judge. Plymouth is great judges. Sometimes we do it with the jury. It really just depends on the case. So once we assess sort of what the strengths and the weaknesses of the case are, then we discuss what are the penalties, what are the consequences, how is this going to affect your life? If you refused a breath test, your license is going to be suspended for 6 months. Can you deal with that? Can you deal with it while I fight it? The only way you could get a hardship is if you can get a letter from work and if you'd be eligible. So we first assess, is that an option? I've had a case this week. It was a crash. I told the client, you're realistically not getting a hardship license. So we might as well look at the case, look at the evidence, and then take it from there. But there's not a quick way to get you back on the road because I think the RMV would deny the hardship license. If you took a breathalyzer, these still winnable cases. So mistake a lot of people make, breath tests, can't win the case. I don't agree with that. I've won a lot of cases with breath test evidence, so we can see how we get that excluded from evidence. You will lose your license for 30 days. After the 30 days ends, you get your full license back. However, you do face a potential 45-day license loss if you're found guilty or later admit to it. There's a possibility of doing things quick. If there's a breath test in the case, we could resolve it within the 30 days. Your 30 days would end as soon as we resolve it, and you just have a 45-day suspension. Generally, we don't have all the evidence at that point, so it doesn't make sense for everyone to do that. It's kind of a rush into a plea, but it's an option. We'll talk about it and decide if that's the way you should handle your case. So when you're charged with the first offense, if the case is going to be in Plymouth District Court, it's a good court. They have the arraignment session. Later, your next court date will likely be on Zoom, and then there's a trial session. I've done a lot of cases with Rockland Police over the years, so call, text anytime if you have questions about what you might expect after an arrest. You can reach me at 781-686-5924. I've been doing this for over 20 years. My passion is helping people charged with OUI offenses in Massachusetts. I've done a lot of cases as well in Plymouth District Court. So if you need help with your case, whether you arrested over the weekend or late at night, feel free to always reach out, get back to you immediately, and give you the help and answer the questions you need answers to make the best decision for your case.